Judge Oakley went from calm to exploding.
I mean, you gotta be quiet while I'm talking. Clear?
And the courtroom couldn't handle it.
And I'm trying to explain it to him too, but I'm not gonna talk over him. And I'm not gonna play that crap today.
Kicking things off, we have sovereign citizen Frank Michaud Jr. stepping into the courtroom like it's his personal stage, and within seconds, the drama explodes.
Mr. Michaud is a sovereign citizen, and no, you say I'm not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it was Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me, is it?
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. He
can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are we on oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, so there's a microphone here.
Ask him now.
Are you picking him up? Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution?
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
From the start, Michaud Jr. plays defiant, refusing to sit where directed, but the judge isn't having it. He lays down the law, reminding him whose courtroom it really is.
I would have nothing less. Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today. May
All
I?
right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam, and could be available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So, with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine.
so today,
You have a jurisdictional argument you want to make?
what sir, no,
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do. Yeah.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is this state?
District courts are legislative courts. That means you're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work under the authority of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And it's not common law.
What-
It's statutory.
It's one thing to call yourself a sovereign citizen. It's another to show up in court and prove you have no idea what you're doing, and this just keeps on getting interesting.
Okay, so it's statutory, that is what, civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on. Is it
My jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking. My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
This is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right, where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I entered sworn.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan, and I are bringing the charges.
Am I injured?
Sir, sit down. Sit down. Sit down, or I will hold you in contempt.
Another threat.
You're probably going to hear more than one.
See.
Even with so much at stake, this self-proclaimed sovereign citizen just couldn't stop himself from challenging Judge Oakley, and the situation only escalated from here.
I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we request a mutual order of sequestration with an exception for the OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
Said I object. What I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of a probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
it says
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting
What is your legal objection?
to not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not.
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections. to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing,
It's
Mr. Michaud.
still is on this.
Mr. Michaud, they're the same thing.
It's astonishing how clueless Michaud Jr. is, relying on internet nonsense that clearly isn't working, and instead of apologizing and requesting counsel, he keeps digging himself even deeper.
I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different day that says a preliminary.
Have you ever had a grilled
If
cheese?
it was different,
Have you ever had a grilled cheese?
it was different. Why would it have two
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, having a court record for reflect, at a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud, that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discoveries.
You don't have to tell me what they are. I know what they are.
I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today. So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh,
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony.
If you thought not showing up was the dumbest option, these sovereign citizen tactics prove there's an even faster way to end up behind bars.
And what point did I waive it? Because if this is a hearing,
You didn't waive it. There's nothing to
you
hold.
would have a right to have a probable cause conference.
No,
What?
you can do that right now. Do you want to make a deal with people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still take preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this day and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to wait? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a fellow, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today. He ruled on his arguments, and that he preserves his right to,
He can appeal them.
as you've already said, circuit court. So he wants to sort of move forward on that defense alone. That the waiver does not preclude him from arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
The judge dismantles each of Michaud's sovereign citizen arguments, maintaining full control of the courtroom.
Now, you want to have an exam today?
Well, I wanted to address some. I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contact.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Listen. You can't tell me something and then just disagree with me.
Well, okay.
Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have the bond.
Okay, I have a bond.
Everyone
I
here
don't-
has the bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you're gonna have a bond, can you express that in a via affidavit so I can have?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent the affidavit of fee schedules for violation of my rights.
There are no fee schedules.
Well, I gave you notice, and
Great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney,
Okay, you said that.
right? And
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize any of that.
United States citizen. I am
Stop.
actually
Hold on. Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud.
Michaud keeps interrupting, misunderstanding the process, and making mistake after mistake, but the judge doesn't bend an inch. He makes it clear that the courtroom runs on law, not on games.
Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, or tell me that, not just from what you say, because ignorance of the law is no excuse for you and nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean prove it. It should mean something.
Can you prove it? Please prove
Can I
it.
prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
Full faith and prayer.
I can prove.
Okay, so
Hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
you proved it for
threatening
me.
me. You threatening me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay.
you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen to me. Mr. Michaud.
You have
Well, I've wasted too much time with you. Yes or no?
So-
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
And I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I reject that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Yep.
Take him out of here.
Color of law.
I can give you more than 30 days.
And just like that, after ignoring every warning, Michaud ends up with 30 days in jail for contempt of court, showing once again that court isn't the place for games.
Mr. Garrett, you interrupt anybody else when they're talking, I'll hold you in contempt today and you won't have to worry about a bond.
Now we have Mr. Garrett, who supposedly ran a dumpster rental and trash business from his house. No license, no certificate of occupancy, and things are about to get interesting when he arrives in Judge Oakley's court.
Judge, Mr. Garrett and Mr. Schick are out of the breakout.
All right. Mr. Garrett, did you go away?
I'm right here.
Good morning. I understand you do not want the benefit of an attorney today?
No.
Okay. And Mr. Schick, where are we at on Mr. Garrett's stack of files?
He's running a business out of a residential home in a residential district that's zoned that way. He does not have a certificate of occupancy, and he also is keeping dumpsters in, which is part of his business in the residence.
All right, so you haven't worked anything out is what I'm hearing.
That is correct.
Okay. So, Mr. Garrett, what's your pleasure? You want to set these misdemeanors for trial and the civil infractions for formal hearings?
Yes.
All right. The misdemeanors, because they're misdemeanors, give you the option of a jury trial or a bench trial. Do you understand the difference?
Yes.
What do you want to do?
Jury trial?
You're going to do this without an attorney?
Yes. It's pretty
You're
much
gonna
black
represent
and white.
yourself.
Yes.
On ordinance violations.
On all of them, yes.
Okay.
Court appointed attorney that I was given he didn't get me any information or wouldn't even answer my phone calls, so I just figured I could do it myself.
Okay, let me just tell you something. I'm gonna be very, very blunt. I've been
Alright.
on the bench for 21 years. I've never had a jury trial on an ordinance violation like this. If you do a jury trial on your own and you lose, I will probably put you in jail.
Hey, that's fine.
Okay?
Judge Oakley straight up delivers sharp warning to Mr. Garrett that he might end up in jail after he loses in jury trial.
October 28th. 8:30 is your trial date.
Okay.
Mr. Kaplan, go ahead.
Was it October 28th, you said?
Correct.
Okay, I just want to make sure. Yeah, Your Honor, with regards to what Mr. Schick has said, he is operating these businesses through all hours of the night. It's trash hauling, dumpsters. He's advertising with his listed residential property that doesn't have a business license or C of O as the place of business. So for bond conditions on this, because I'm sure I'm going to have to file a show cause probably today, we would request that you order him not to have any business in any place in the city of Romulus without a business license. And just with the acknowledgement that if he's found to be violating this, we will be filing show cause motions.
Mr. Garrett, any response to that?
Yeah, well, I don't conduct business out of my home, ever. Not one time have I conducted business out of my home. Just because I have an address, my address is my business address. I think that's connected to my business. It's a dumpster rental company. The customers don't rent the dumpsters at my house. I take them to them. And
Where are you storing the dumpsters, Mr. Garrett?
what was that?
Where are you storing the dumpsters?
Where do you store the dumpsters before somebody rents them?
Well, before I got the no C of O and all these other tickets. They rent out so easily that you'll take them from one location and take them right to another location. I've never once
So
rented a
you're not-
dumpster in my at my home, and when I clean out the foreclosures for the banks, I can't remotely clean them from my house. I have to go to the location to do it. So they're wrong about running a business out of my home. I might work on some equipment there, like my trucks or something, especially through the pandemic, because there was a stay-at-home.
That's part of your
order.
business, Mr. Garrett. That's part of your business.
Yeah, but if they're personal vehicles I use sometimes for
If
my
I'm
business.
if I'm a trucking company and my job is I haul freight down the road, but I work on my semis in my driveway, that's part of my business. Do you understand that? So are you telling me you've never had dumpsters or dump trunks at the Whitehorn address?
Business related? No, sir.
Mr. Garrett insists he doesn't run his business from home, claiming the address is just for paperwork and dumpsters are stored elsewhere, but the evidence tells a different story and Judge Oakley is not going to slide it.
And they would have to be.
I've never had anybody that, has a dumpster at their house for pleasure.
Hey, well, just because you have them doesn't mean don't exist. And I've also been, if you look.
All right,
now,
let's be clear then, Mr. Garrett, because I don't like your smart ass attitude.
I'm
If
not
there's a
being-
dumpster or a dump truck on that Whitehorn address while you're on bond, that's a violation.
They're not dumpsters, though. They're not. I don't have a dumpster. I don't even have one dumpster here. Utility trailers with sides on them. I built them personally.
Then I'll order
Your
no
Honor,
utility trailers there.
Your Honor, I
Like
apologize.
changing
but
ordinances.
Your Honor, I apologize. Mr. Schick's waving a photo right now of the dumpsters on his personal property. Those look like business dumpsters to me, Your Honor. With
Where's
a
the
company that
commercial
has no
freedom?
business license.
Mr. Garrett,
right now.
Hold on, Mr. Kaplan. Mr. Garrett, you interrupt anybody else when they're talking, I'll hold you in contempt today and you won't have to worry about a bond. Is that clear? Mr. Kaplan, go ahead.
Your Honor, and I apologize because, like I said, I was going to file a show cause motion on this pretty much immediately. But he's lying to you right now in front of you, which is contempt of court possibly. He is, Mr. Schick has photos of the dumpsters on his property that he's saying are never there. I have advertisements on Google with his his residential property listed for D's Dumpster and Clean Out and D&M Dumpsters and these things. I have his Lara that has his company listed as his home address, his Lara filing. We have videos. I mean, this has been an ongoing issue for the neighbors.
All right.
And he's obviously explaining to you right now that none of this is going
I've
on.
heard enough. I've heard enough. Mr. Garrett, listen to me. You're digging yourself a hole, brother.
With photos and ads proving dumpsters are at Garrett's property, his story falls apart and Judge Oakley is ready to shut him down.
You're digging yourself a hole. What you need to do, if you're going to be in business, what you need to do is go out and hire an attorney that can advise you on business matters. One of those things that attorney is going to advise you is you can't do this kind of stuff out of a residential neighborhood. Sit down with the city, find out what you have to do to be in compliance. There's property in the city of Romulus where you could do all this out of and probably even afford it. But who's going to run your business if I put your butt in jail? Don't get your back up, dude. There's a right way and a wrong way to run a business, and you're not doing it the right way if you're trying to do it out of that address in Whitehorn. And from your mouth, you're running it there. You're working on your trucks there. That's part of your business. You tell me what you want to do. You want to try to comply with the city of Romulus, or you want to fight this?
I already tried been complying with the city of Romulus for a long time now.
All right,
Please
here's
don't
what
answer
we're
my
gonna do.
phone. I got Mr. Kaplan saying that he's gonna take my house from me in the breakout room last court date. There's no way. I'm not doing anything on it. You know.
Are you clear that your bond condition is you don't have anything on that address other than passenger vehicles? No RVs,
Isn't the
no
ordinance,
horse trailers.
The ordinance though is 2 trailers, right, per lot?
I'm not talking ordinance. I'm talking my bond by bond conditions.
Your Honor, he has multiple trailers.
I didn't ask you anything, Mr. Schick.
Sorry.
Mr. Garrett, do you understand what I had just said? Nothing but passenger vehicles.
This guy believes that because he works at customer sites, it's not a home business, forgetting that his home is the registered address. Did he honestly think the court would accept that?
I understand what you're saying, but I don't see how that's right. There's a right and a wrong way to do this.
Then you can appeal me.
All right.
If I lived in your neighborhood and what it sounds like is going on, I'd be real upset. I don't think that's fair to the residents.
Well, it's not also fair to me that they're threatening to kill my dogs and calling the police on me about my dogs being at large, which I know they haven't been.
Then you need to go to the police and make reports about threats. That's not in front of me today. What's in front of me is what apparently is a business being run on Whitehorn. So to make sure that stops today, I'm ordering you nothing at that address other than residential passenger vehicles. No commercial vehicles, no horse trailers, no utility trailers. Clear?
I don't see how that's right though, sir.
I'm not asking you if you agree. I'm asking if you understand.
Yeah, I understand.
There you go. Nothing else. October 28th is our jury trial date. Once again, sir, I would highly advise you to go talk to an attorney, a business attorney, and get some advice. Yes, sir.
And Your Honor, for the record, Your Honor, for Mr. Garrett, if an attorney does reach out to me, I am willing to work with him, with any attorney or Mr. Garrett, as long as the house is not being run as a business and prevent a jury trial and possible jail time on this case.
I appreciate that. Mr. Garrett, you had a question?
Yes, I have my camper here, and what do I do about that? I just have to go pay to store
Park it somewhere else.
Okay, and
That's how it ended for Garrett. Every lie exposed, and Judge Oakley left no doubt that the law comes first. And that's exactly what happens when you bring a non-serious attitude into a courtroom. These judges don't play around. What did you think of the takedowns? Drop your thoughts in the comments, and don't forget to like, subscribe, and hit the bell so you never miss more jaw-dropping courtroom moments like this.